I'm attorney Mark Nicholson from the law office of Mark Nicholson, and I'm here today to talk about the Jonathan Majors sentencing. It did not go. It was continued until April. It was continued until April the 8th due to an appeal from the actor's lawyers to vacate the verdict. So this isn't really an appeal like it's going to the Court of Appeals. They're basically asking the court to set aside the judgment, set aside the verdict. And in Indiana, we have something that's called Trial Rule 60, where after the verdict comes out, there's certain criteria that can form the basis for the judgment to be set aside. And basically, some of the grounds that you can argue for the reasons why the verdict or the judgment should be set aside is any ground that they think can be raised on an appeal, but can be addressed by the trial court that will require it to be overturned as a matter of law. Or there is something that happened outside the presence of the court, some kind of improper conduct, something that would affect his substantial constitutional rights, and he did not know prior to the verdict being given. Or there's some kind of newly discovered evidence that could not have been produced at the trial to the defendants, even if he used or she used due diligence. So there's some grounds that you can argue why the judgment should be set aside. Normally, every trial I do, I always do like a trial rule 50A, which basically I ask the court for a directed verdict to say, hey, the state did not prove their case, go ahead and dismiss. Some of the reasons that Jonathan Majors' team is asking for the court to set aside, the trial court, not the appellate court, the trial court to set aside the verdict is because of, here's a few reasons. One of the reasons why apparently they want this motion to be granted is because they believe there was insufficient evidence presented at trial. They believe that they're inconsistent charges, that the prosecutors were arguing a intentional act, that he intentionally harmed Jabari, but yet they also threw in this reckless. So how can you be intentional but yet reckless? So it's like they just threw that in there to try to get a conviction. So they're saying that, hey, this is not really a valid charge, that was improper for there to be a reckless charge. And the state got a conviction on something they really didn't argue, because the whole entire trial they were arguing that this was an intentional act and not a reckless act. So because of that, they feel like they weren't given, that his constitutional right was violated, that this was not fair, that his constitutional right to a fair trial was violated because of this inconsistent charging information. This is just some of the information that I heard may be argued in the 330 motion. It's called 330.30. That's the kind of motion that was filed, a 330.30 motion that was filed. Now, apparently there's not been a copy made public, and there's not been a copy provided by the defense. I'm not sure exactly why they wouldn't provide a copy if they felt so strongly about it. It's like, boom, go ahead and put it out there, start, telling your side of the story. But I'm assuming whatever reason they are kind of keeping it quiet. They have a good reason. Also with this is the fact they wanted to keep private, sealed some of the information that came out or that did not come out during the trial. They want to keep this private, and they filed a motion to kind of keep this information sealed, and the mainstream media is trying to get copies of it. Now, what I said, the judge knows this information because apparently the information is in the file that he's trying to keep sealed. So there's nothing that really at this point would prevent the judge from looking at that information and factoring it in during sentencing. And that goes back to what I was saying earlier about any kind of allegation of, mental health issue, any kind of allegation of, some kind of abuse towards other women, whatever this information is that the defense is trying to keep sealed, most likely it is not anything that is helpful to the defense. It's hurtful to the defense. Doesn't mean it's true. Could be all completely false. But state obviously wants it in and out to the public, and the judge could sit up there and look at it and say, hey, I'm going to give it the much weight as I think is due. And the judge could give it a lot of weight, no weight at all, or some weight. So whatever that information is that we're not privy to is damaging to the defense, and that's why they want to keep it sealed. Also, with this motion that was filed, it is clear that they want the verdict overturned, and they think that there's something they have that will get the verdict overturned. Without knowing exactly what they're arguing, other than the speculation that I've heard about and read about, I don't know how strong the chance is of it getting overturned. I know in Indiana, usually when you file these motions to set aside guilty verdicts like that, they're very, very hard to get overturned when you're trying to ask the trial court to set aside it, because it's like you're disregarding the jury. The jury had heard the evidence, they came up with a verdict, and then the judge is going to go ahead and just say, I'm just setting it aside. Now, if there's legal grounds to do it, maybe the judge will do it, but it's really hard to tell in this case without knowing the specifics of what they are arguing. And it's interesting too that it seems to be filed like at the last minute. Why, was that strategic that they waited until, kind of like today, to file this so they could have a hearing where Jonathan Majors was not present. He appeared by video court. So just the timing of it, maybe to delay it even further, not file it earlier, because if they filed it earlier, then the judge could have ruled on it and they could have still had the sentencing in today. I don't know the reason why, but maybe it just took them that long to draft the document, draft the motion. But it just seems like it could have been done earlier. But once again, I don't have all the information. And this could be a strategic way to delay his sentencing, to gather more information. Maybe they weren't ready. They have who knows? But obviously the attorney's not just doing things. His attorney's not just doing things for no reason. There's a reason why the motion was filed at the time it was filed. There's a reason why she wants certain information sealed, and there's a reason why she has not released the motion. I do believe their motion will become public at some point, so you'll be able to see the arguments that they're making about why it should be dismissed. And the prosecution will probably release theirs, saying why they believe that the charges should stay, that the conviction should stay, that you should listen to what the jurors say. This is really interesting. This case has taken a lot of twists and turns that I find to be highly unusual for a misdemeanor, but given the fact that he is a movie star, Hollywood, all that kind of stuff like that, then makes it more understandable about why things are going kind of crazy town with, stuff's getting in, stuff's not getting in, she's saying this thing, the prosecutor's saying this thing, and just all the kind of twists and turns this case has taken. I find it fascinating, unusual for a misdemeanor, but once again, you're talking about the high stakes, tens of millions of dollars over a lifetime, you're probably hundreds of millions of dollars that he's missing out on had this not happened. So stay tuned. I guess on this issue, we'll come back again because he's set for sentencing on April the 8th, and we'll find out what his sentencing is. Now, this does not change my view about what his sentence is going to ultimately be. I don't believe there's going to be any jail time. It does not change my view. It's too hard for me to predict if the judge is going to set aside the verdict because I haven't seen the information out there. But I would be surprised if the judge did set aside the verdict. And the only reason why is because I feel like if it was so strong, if their evidence was so strong for reasons to set aside the verdict, why wouldn't you go ahead and put that out there? Because the prosecution is going to get it. So there's not anything really to hide. So why wouldn't you put it out there? There may be a strategic reason why not to do it, but it just seems like to me that if your evidence is that strong, why wouldn't you be like, bam, this is the reason why this case should be overturned, and you put it out there in the media, and then people in the media start talking about it and start thinking about this is the errors that you see in the case about why it should be overturned. So I'm looking forward to seeing that document and reading it and giving you guys an update about what my thoughts are regarding the document when it's made out to the public. This is your Nicholson Nugget of the Day. Please be sure to like and subscribe.